As I was sick on Thursday and I wanted to write my presentation in the bus, I didn't do it, but I collected my thoughts yesterday and I have some slides. I will talk a little bit about my work and about my forthcoming book and basically about the problem, I would say, on the relationship between history and international criminal justice and transitional justice, perhaps more in an overarching sense. And I'll also talk about what type of evidence, historically, is being used in criminal trials. And I did it from the perspective of a trial observer. So I see trials as workshops of historical facts, but also of truth finding. And I'm also going to talk about different types of truth. I'm really bad in time management, and I'm looking at Kamari, so maybe you can give me a sign when I still have 5 minutes. So I'll be able to work towards a conclusion in time and give Alphonse, of course, all the way to speak. Just trying to find that out. Okay. Wonderful, thank you. So basically my work now involves writing a book which I call Transitional History. Obviously you are familiar with the term transitional justice. As I said in one of my comments earlier already, historians are not so much a fan of the word transitional justice because we also perceive it as a historical phenomenon, but we also perceive it as an industry, a human rights industry, which obviously comes with a lot of normative and doctrinal elements to it. And as historians, we're mostly interested in the past. We're not about changing the future or pursuing venues or areas of justice. And I think when thinking about the word transitional history, I think what transitional justice really is about is changing the narratives about how we perceive the past through the prism of the present, working as well towards the future. So it has a future element in it. Well, my question really is, how do societies and political and judiciaries use and abuse history and historical narratives in pursuit of justice and accountability, and also, of course, related questions like peace building, reconciliation, and all those other things. So basically the book deals with the question on the relationship between history and international criminal justice. And of course these two elements are very much connected, because every legal case or every transitional justice phenomenon, so to say, is always a response to the past, right? So it's always historical from the get-go. So the past is a trigger for transitional justice mechanisms to start. Also history in transitional justice procedures, of course, is foreground because it's all about the past. Also they work towards historical documents, judgments, or reports if we speak about truth commissions. And I'm going to be very critical. I'm going to say that the judges and lawyers are very bad and irresponsible when it comes towards dealing with history, and I'm going to explain why that is. And I also do that in the book. So I separate between recent and remote historical wrongs. And obviously we've been talking already about the temporal distances, right? If we look at Ukraine now, the war is ongoing, atrocities are going. These are very recent historical wrongs. They're quite easy to investigate right after the events as they go on. And of course we've also been speaking about remote historical injustices. We can think about slavery, for instance, or colonization. And of course, these are questions that pop up much more now in the field of transitional justice and historical reckoning. Obviously, they also are addressed by different fields. I think recent historical wrongs can still be dealt with by courts, because the perpetrators are still alive, victims are still alive, witnesses are still alive. But the more we go back, the more complex that becomes, and we enter the field of history, or philosophy, or ethics. So also in the book I deal with different types of historical justice. I'm interested mostly in for criminal trials, but also civil trials. I come from a civil law tradition in the Netherlands, where we of course also deal with atrocity crimes, and also truth commissions. I think these two often promise as well to establish the truth, right? We all know that the truth doesn't exist, so it's a judicial truth or a social truth. So those are the promises, and I also critically question the promises of transitional justice. So if you look at the statutes of many courts and tribunals or truth commissions, they would always say that after the experience of justice, we would come out with the truth, right? But it's this very specific truth. And also having investigated many international trials and having read a lot of judgments, often this is not the case, right? Nobody reads a judgment if you want to read about the history of Rwanda, or you're not going to pick up Mladic's judgment at the ICTY if you want to read about the history of Bosnia. Also, what I criticize in the book is the use specifically, and I would say also abuse, by prosecutors in the adversarial system in basically litigating very specific historical case narratives. This is a problem in the adversarial system because basically you have to sell a story to a judge and you have to stick to that story and it has to make sense. But then comes the problem that you also have to prove it. So you actually have to show evidence to support the charges and the case theory. And specifically looking at the ICTR, but also the Special Court for Sharia and the ICC, my conclusion is that prosecutors have been very irresponsible in formulating historical narratives and prosecuting them. And the consequence thereof, and of course this has been mentioned, is that if we look at the ICC, many people have been acquitted. And the reason thereof, therefore, is basically because of bad case theories and bad evidence. So my conclusion as well is that prosecutors should deal more responsibly and responsibly with questions of history and historical evidence. So my work in the book basically deals with three tribunals, the ICTR, the Special Court for Sharia, and the ICC. And my methodology, I can only describe afterwards. This is basically how historians work. You just do a lot of stuff. You find out facts, you go about, you travel to Rwanda, as I've done for many years. And in the end, I've observed the trials of 160 accused at all the international tribunals, all the cases at the ICC, the Special Court for Sharia, and the ICTR. And basically the conclusion is I have no argument in the book. Historians don't work with arguments, we just come to a conclusion. And the conclusion is that tribunals are bad at writing history. I mean, that's quite an obvious conclusion which you could already fantasize about. But basically what I do in the book is explain how that comes about and why that is. And what the problem thereof is as well, because we perceive judgments of tribunals as being authoritative, right? A judge writes our history, so we believe it. But we have to understand how judges actually come towards those conclusions, and also what have been their limits. I'm using a PDF, so basically I ask also some other questions in the book, and these are epistemological questions. I'm also coming from a field of genocide studies, so basically we inquire about atrocities, the causes, the courses, and the consequences. And I think how historians go about is asking basically three very primary questions to the sources that we engage with. Is what can we do? Right, looking at, for instance, the genocide in Rwanda, which has happened in 1994. We now live almost 30 years after. Of course, a very important question is what in the present can we still know about what had happened in 1994 and the years preceding. So also what do we know and also what don't we know? I think that's also a very important question. And also what are the reasons for perhaps not being able to know about atrocity? And obviously, if we look at many cases of mass atrocities, of course there's the element of denial when the crimes are ongoing already. sources are often being destroyed as crimes are being committed, right? So that poses, of course, an epistemological question from the get-go. So how do we know it? I think that's also a very important question, and also that relates to the sources that we're going to look at when dealing with international justice or international criminal justice. And basically I'm going to run you through several historical sources and evidences, and also ask that question. What are the sources telling us, and how do we know, what do we know, and how can we be critical towards what we know? Some elements and some perhaps ingredients to sort of picture what the difference between a judge is and a historian. The first, most important thing, I think, a judge works in an adversarial system, so they have to pick between stories. A story presented by the prosecution, a story presented by the defense, and the ICC also a story told by the victim's representatives, right? And a judge basically is the arbiter of narratives and picks perhaps the most believable one. Historians are not restrained by picking stories or choosing between them. We work inquisitorial, which can also be quite disappointing for many people because the conclusions are often not black and white, right? They can be incredibly nuanced. Just think about your own life and your own past. It's not one straight story. There have been ups and downs, and people would also have different opinions about it and look differently at it. Also, there's, of course, the elements of the burden of proof. Judges work with the burden of proof of beyond any reasonable doubt, right? So if there's a story and there's one single doubt, it should actually already be set aside. Of course, this doesn't happen always. Historians have a much more lenient burden of proof, which is the balance of probabilities. So how probable is it that somebody was engaged, for instance, or involved in atrocities? And of course, this can also change if evidence or later evidence pops up. And conclusions can be nuanced afterwards or on the get-go. Also very important is that judiciaries work within a judicial straitjackets. Floriba earlier this week talked about the ICTR and how it was limited in how it could deal with Rwanda. Because basically the ICTR could only deal with one calendar year, 1994. It could also only deal with crimes, and not with really questions about history. And of course the questions of history is why did certain events happen? These are not a question for judges, right? Perhaps they look at motives, but motives of course are something else, or intent, it's also something else. Also when we read judgments, I think it's very important to differentiate between judicial documents, which basically write agency history at best. It's about a single person, the accused. It's not about the entire history and the entire context in which that person has operated. And of course, historians deal much more with questions of structure. As I said, we deal with the causes, what caused the violence, how did it go about, and what are the consequences as well. So the questions are much broader in that respect. Another important difference, of course, is that judges work towards opinions. They orientate themselves towards punishment, right? So the end result of a legal case, obviously, is imprisonment. Historians don't work towards imprisonment. We work towards understanding history, but also explaining them. So also the end goal is very different. And also historians are not so much restrained by actually having to deliver a final judgment, right? We can always revise and revision our knowledge and come to new conclusions in the future as well. And of course, that is also a very important ingredient when we think about transitional justice and new questions, right? Are judgments from 1945 still applicable? And do we think differently about those questions that were asked back then? But the judgments still stand, but we can think differently about the Nazi regime, for instance. This is a very long slide, but I'm going through it quite quickly. And I want to separate between facts and truth. Historians basically, and of course this is an ambition, because we cannot always pursue, I would say, success in that respect, but it's to be as dispassionate as possible. Try to put ourselves in a distance, I would say, from emotions, politics, but also legal questions. So I always like to come up with a quote by Herodotus, of course, the Greek historian, who wrote that I'm not in a position to comment on the justice or injustice of the acts. All I can do is report on what is being said. So basically, this is the work of historians. Also, as a trial monitor, that's basically what my work involves. I don't report on whether I agree with something or disagree with something. I think I can be much more modest and just report on what people say and perhaps explain for what reasons. I think the latter question is actually quite an important one. Then, of course, there's factual or forensic truth. Again, I quote the historian Leopold von Ranke, who said, a fact really is about how it actually was. Right? So we just talk about dates, places, perhaps license plates on cars, if we talk about crime scenes. Another aspect, and I think this is really important in transitional justice, is the element of narrative truth. So these are facts as they are related by human beings. Obviously involved or informed, I must say, by their opinions, by their own memories, about anything, basically. Also what they have read, and also their emotions. I'm also adding audible truth. This is the truth being perceived through language as we listen to it, which is different from documentary truth. You can read from a transcript, for instance, and pick up some knowledge from it. But if you listen to something as well, there's a different process of actually digesting that information. So it's also internalizing a specific type of truth by speech acts. And of course there's dialogical or democratic truth. And this is the truth that's being sought after, often during truth commissions, where there's a conversation between victims on the other hand, on the one hand, and perpetrators on the other hand. And perhaps, I'm not saying that it always is the case, but a truth that can come out that is reconciliatory, for instance. There's also restorative truth. This is basically truth-telling as a means of catharsis. People sometimes didn't have the opportunity at all to speak about their griefs and violence that has been committed against them. And being given the opportunity to speak about it can, as some scholars say, actually be restorative or even healing. We can, of course, discuss those questions as well. There's punitive truth as well. I'm going to talk a little bit about it, and I'm going to talk about the genre of the NGO reports. Basically, this is scandalization, right? Naming names of perpetrators, of course, is an element of punitive truth, with huge consequences also if you are actually not guilty of offense. I've talked about legal truth as well already, and transitional truth. And transitional truth really are perceived as a genre of truth which is being told through a human rights discourse. It's often also quite activist, right? So it's not always scholarly or scientific. I want to make that distinction as well. A great book actually to read about how to deal with questions of history, but also elements of history that are not discussed. And Kamari, of course, in her first lecture also talked about that. There's a book, Silencing the Past, by Michel Trouillot. Also how to deal with archives that are not present, for instance, or alternative sources of information on history. How is it doing in time? All right, historical evidence. This is what I'm going to talk about. So first of all, I must say that I work for a specific institution, which is the NIOD Institute for War, Holocaust, and Genocide Studies in Amsterdam, which was set up in 1945, directly after the Second World War and the German occupation of the Netherlands. Arguably the oldest transitional justice institution in the world. And it was set up for the sole purpose for Dutch society, but also Indonesian society, and citizens to bring to the institution documents. The most famous amongst those is the Diary of Anne Frank. I think everybody knows who Anne Frank is. And of course that's historical evidence provided by people who have experienced violence or occupation. Or in the case of the Netherlands, of course, the Holocaust, because a genocide was committed and perpetrated in that country as well. So that's a very direct and immediate I would say, response and question to society to immediately proffer evidence, which can be used for future trials. And in the Netherlands, this has been used for trials. So we had special prosecution services between 1945 and 1949, which dealt with 300,000 cases of collaborators with the Nazi regime and also certain war crimes. 150,000 of those people were also found guilty for those crimes. So actually the material on the recent historical wrongs was immediately used in criminal trials by which a lot of people were sentenced. I can have some critique on these trials as well because there were 5-minute trials, so there was no defense, but you sort of get the idea on how it worked. This picture, and this made me incredibly excited when I was here walking with Lucy, just on the way to the Genocide Memorial just next door. So we walked through the memorials, so the graves, and of course the stone with the names of victims there. But when we walked down there, we found actually this dungeon, or this room, where a lot of archivists were basically separating, categorizing all the documents that were produced and collected by Ibuka, which is of course the victims organization here in Rwanda. And it made us extremely excited to see that there's actually documentary evidence now finally actually being organized and also being digitized, and in the future being made accessible to researchers, but perhaps also to judiciaries. And there's really a lot of information from receipts of buying paper, which perhaps you cannot use in a criminal trial, all the way up to judicial records. So the variety of sources is quite big, and it made us really excited because I think as historians, what we really like are primary sources. We don't care so much about the literature, to be honest. Our starting point is read the sources first and then read the literature. So we work perhaps a little bit in a different reverse way. I'm going to speed up a little bit. What types of historical evidence can we separate and sort of pinpoint? And I want to go back through, I think, the advance of transitional justice, and specifically in Africa. And I want to go back to the Congo Free State, where, of course, as we said, the first time the word crimes against humanity was used, but also the first ever International Commission of Inquiry was being instituted. And one of the most important sources, actually, for those transitional justice mechanisms to be set up was photography. So there were a lot of missionaries at the time in the Congo who were making photos of abuses. And this is one example that depicts Nsala, who was a Congolese man who was forced to work on a rubber plantation. And you can also see that in front of him, the picture isn't very clear, but there is a separate or severed hand next to him. So one of the main atrocities in the Congo Free State, if people would not get their quota on the rubber, their hands would be chopped off as a punishment. So this was the key atrocity at that moment. And it was being publicized through means of photography in Europe and the United States of America. And of course this led to a lot of outrage and also the establishment of the Congo Reform Association, which to my mind is also perhaps a sort of organization we can compare with Human Rights Watch nowadays, first human rights organization. Obviously nowadays, again, we've been talking about digital and technological evidence. Photographs are again very much important sources in criminal trials, because many atrocities are being photographed in Syria, most particularly. Then, of course, there are archives. The best sources, I think, for courts, but also for historians, are the perpetrators' archives themselves, right? So the picture on the left are the archives of the Nuremberg Tribunal. And obviously the case before the International Military Tribunal was so easy because the Nazis were so incredibly meticulous in documenting their own crimes that the prosecution can just use those documents in order to prosecute them and sentence them without actually much reasonable doubt, right? So that's the standards. We also know that in many tribunals there is actually a lack of documentary evidence. So there's only been quite some examples of tribunals that actually had the advantage of dealing with documents that were produced by the perpetrators themselves. So the picture on the right are the secret records of his Habre, which basically are the records from his secret prison, which were also torture reports. And on every torture report on single individuals, there was his signature. And also, basically, of course, for the trial at the Extraordinary African Chambers, this was a key piece of evidence because it tied immediately the victim to his Habre. And of course, that was very usable. Obviously, archives are not produced so much anymore by perpetrators because also they know that archives can be used in the future for criminal prosecution. So you always see that there's a policy or a dynamic of destroying archives. This was the case already at the International Military Tribunal for the Far East, where the Japanese immediately destroyed all their archives. And this also posed immediately the problem, what source next if we don't have the best source available? And there comes in basically the genre of witness testimony. And in Tokyo it was already described as second best evidence or the best available evidence. And of course witness testimony has a lot of problems to it because basically it relies on the memory of people. Just ask yourself how reliable your own memory is when you think about what you've done last week, or what you have been wearing on Tuesday, what you have been eating on Wednesday. I think this is a very problematic source. Also, having been an investigator, having questioned a lot of witnesses, I think I come to the conclusion that oftentimes there's very little truth that comes out of the memory of a person. So it's a very delicate source. The picture next to it is a witness in the trial of Adolf Eichmann. And why do I have the picture there? Is because witness testimony from the 1960s onwards was not only used as evidence, but also to make trials less boring. Because when you just deal with archives and documents, a trial doesn't speak to society. So what the Israelis were thinking in the 1960s is that the trials should also speak to audiences. And this is the reason why they also asked witnesses to come about and tell about their experiences. Although in the Adolf Eichmann trial, all the witness testimonies were not used as evidence, because in that trial there were also archives which bore Adolf Eichmann's signatures, right? So the crime was already quite easy to prove. Forensic evidence, of course, is another source that is being liked a lot by judiciaries, but also by historians. Basically, it tells the story of the facts. And of course, we've been to Marandi. We've seen there what the result of mass violence is. It sort of gives us a clear picture. And it also says something about the truthfulness of the act. Right? We still have an artifact of the atrocity. And we see across different tribunals that forensic evidence was tendered. So the picture on the left depicts basically researchers from the Argentine Anthropological Committee that was using exhumations in the trials in Ethiopia before the tribunals there was started in 1992. And a lot of that information was being used also to identify victims by their names, by their ages. Which of course is important if you want to prove the crime and also connect it to the perpetrator. The other picture is quite gruesome, so I'm going to move to the next slide, but it's a picture from Srebrenica. A lot of exhumations were being done by the IC2I in Srebrenica, and so far I think all the estimated 8,000 victims have now been identified by name. So I think that's a hugely important source, not only for judiciaries but also for historians. And of course, also when victims are giving their name, I think that also adds something to their acknowledgement and also answers questions that families may have about what had happened to their loved ones, right? Where they were buried, how they were buried, and perhaps how they were murdered. I'm going to speed up because I have 10 minutes. Thank you, Karen. That is the issue of the UN report. The UN report is being, like judgments, being considered as being very authoritative, but also very problematic, because the United Nations, of course, as we know, is a political organization. That in the first place. So we have to question the author of the documents. Also, and I think we've seen this in many trials, and oftentimes you need defense lawyers to ask critical questions, is the question is who is actually been producing and investigating the reports. And if you see commissions of inquiry, usually these involve 3 people, and they investigate the genocide in Darfur. How on earth, with 3 people who are usually not trained in investigations, just lawyers, actually produce a report that can be used in a court of law, right? So we're talking about the verifiability of the sources, for instance. Usually they speak to anonymized witnesses. Of course, this is a very important question for judges, is how to assess the credibility of the evidence that also is contained in the UN report. So it's a quite problematic source, but it's being used as being very authoritative, and I'm having critical thoughts about it. The same for the NGO report. Especially the ICC has used a lot of NGO reports in the beginning, but as I said, it's a genre of scandalization. NGO reports are produced for very specific reasons. It's to name and shame perpetrators, it's to spark change, but also it's to spark international criminal investigations and trials of people. But often there are times, many times used as the prosecutor's first draft of indictments. And the book by Alexandre Desforges, which was of course produced on the genocide in Rwanda, is a key example thereof. So the entire narrative of that book has been ingrained in all the prosecutions at the ICTR. It's a very specific telling of history. There's political bias, of course, because human rights organizations are political organizations. There's a very specific legal narrative because they try to frame the evidence immediately in terms of crimes against humanity, war crimes, and genocides. So they're not so much about the facts. They're very specific in what was being looked for. And of course, there's the question again of unverifiability, because a lot of NGO reports are based on anonymous sources. And we've seen in ICC trials when Human Rights Watch investigators, for instance, were questioned about their sources and about their methodologies, the judges have ruled that their reports were not usable because they couldn't proffer actually their sources and their methodology, which of course is important because you have to know whether something is true or not. Witness evidence. I think I have 4 more minutes. I don't want to steal too much time. Yeah. As I said, witness testimony is incredibly complicated and problematic. How I perceive it is much more as a genre of transitional testimony. What I mean by that is that witness testimony is being elicited and extracted from memory from specific people with very specific questions. It's not an open question to a witness saying, you were in Rwanda in 1994, describe everything that you have seen, heard, or learned about in that period. No, it's about who have you seen? Have you seen this person? Do you know where they were? So it's a very specific and controlled type of evidence, which also, of course, enters into the transcripts thereof. So it's a very specific narrative. Then there's different types of witness evidence. Of course, victims, which oftentimes in international criminal trials are not the most usable evidence. Yes, they establish that things have happened, but it doesn't always say who did it and connect it actually to perpetrators. Then there's bystanders, of course, people who have seen it, but perhaps were not so much part. And oftentimes these are Westerners, journalists or NGO workers. Then there are perpetrators, and of course with perpetrators there's also a lot of problems because of self-incrimination. What is the perpetrator actually going to say to a judge about their own role in atrocities? And what are the reasons for them to testify against their former bosses, right? Is that because they are being relocated to European countries, for instance? So I think we always have to ask these critical questions. So basically I see them as judicial oral history. I'm going to skip the part about expert witnesses, but perhaps we can talk about it because I want to just come to the conclusion. Or perhaps talk about one case that I think is really interesting for you to look at if you want to sort of understand the questions that I've been raising and the problems, is the case of Laurent Gbagbo before the ICC. Obviously, Laurent Gbagbo is not only the former president of that country, but also he's a former professor of history, as was his wife, Simone Gbagbo. So actually, on trial was an historian, and indicted was another historian. And in this case, I think it's really become very clear on how bad prosecutors were in framing a case, litigating a case, and proving a case. And I think the reason for it starts in the beginning, because the international criminal justice industry, I would say, always starts from the premise that you're guilty until proven otherwise. And I think that's really the problem, right? So basically, prosecutors start with a thesis that somebody's guilty, think about an argument, and then try to find evidence to support those arguments in the trial. Of course, this is a very problematic way of doing things in a scientific way. Because what if there's no evidence? And you have already indicted somebody, arrested somebody, and put them on trial. This is what happened in the case of Laurent Gbagbo. Not in the last place, if you read the indictment, if you ask a first-year student in history, they would shoot holes in it immediately because it's just so incredibly amateuristic. Because basically what they say is that the crime that was committed allegedly between 2010 and 2011 had already started somewhere in 2002 when the Gbagbos made a criminal conspiracy among the two of them to commit crimes 10 years later. I mean, it's such an unbelievable theory, but this is what they put actually before the judges. And then when it came to trial, they didn't have any evidence. There were no documents. There were several witnesses, but the witnesses actually, the prosecution witnesses, were not to substantiate actually the case theory by the prosecution. They were telling totally different stories. And of course, this led this case to collapse halfway, where Laurent Gbagbo, who hasn't said a word during his trial in his own defense, didn't even have to put up a defense anymore, right? The consequence of that is now that he's being cleared by the international criminal justice system. And of course, he's now writing books again on how he's an historical figure with no blood on his hands. And uses that, of course, for political reasons in Côte d'Ivoire now. Towards the conclusion, I'm sorry for stealing a couple of minutes. Future challenges. I think we've been talking a lot about temporal distances, which I think is crucial. Kamari, your question in the beginning has been lingering all the time in my mind, is how far do we go back? I was recently reading Mahmoud Mamdani's wonderful book, and basically he says we should go back to 1492, the start of colonialism in the New World. But how are we going to do that in terms of historical evidence? I think this is a crucial question. What is still available, and how to assess types of evidence? Is it witness testimony? No, because there are no survivors. Is it oral history? Yes, perhaps. Or are there specific stories, like you have told about, the Anansi stories in Jamaica, which of course are also historical sources. So I think transitional justice can be also much more creative in terms of what sources can be used. There are truth commissions that are already going back quite far. Like the Burundian Truth and Reconciliation Commission has a starting point in 1885. 1885, of course, as you all know, was the Berlin Conference, which basically decided on the partition and the scrabble for Africa among the European powers. Of course, this was a joint criminal conspiracy and enterprise in Europe, and it started a huge crime in Africa. When we talk about the ICC, of course this institution is becoming more historical by the day. The cutoff date is July 2002, but this is a permanent institution, so by 2016, the ICC can deal with very historical cases, and perhaps also has to deal with the questions that have been raised. So what are the platforms in order to deal with historical questions? truth commissions, I think, because they can be much more historical, but also a new genre of people's tribunals, and we have them quite a lot. There was a recent one in New York on genocide in the United States of America. There was one on the Uyghurs in China, also in Indonesia. So I think this is a very interesting new platform, without perpetrators on trial, but history on trial. And I think I just want to leave it with that, if you will allow me. Thank you very much, and I hope you understood what I said.
Thank you, Thijs, for this wonderful presentation, and also for your great, amazing, profound reflections. Really, really moving, and you got me really thinking as well. I've got a question. I mean, it's got like 2 parts to it. I'll try to keep it short for Thijs. On your slide entitled "Knowing Atrocity," you listed, what we can know, what we know and what we don't, how we know. But I didn't see, who does the knowing. And I know you kind of talked a little bit about it later on, but I was really wondering throughout, the who does the knowing and whose knowledge matters and is listened to, right? Speaks to power and so on and so forth. And specifically in the case of Laurent Gbagbo and Simone Gbagbo, I mean, the trial was very clearly from the outset a political trial, right? And I mean, from the outset, before the confirmation of charges, people in Ivory Coast and in the diaspora were very upset over the way that the trial was being framed, and were vocalizing that, right? There were lots of protests in, was it Malieveld, in The Hague, at the prison, throughout the trial, right? Well, before then, throughout. And no one was listening to that. There was very little media coverage of that as well. And with Simone Gbagbo, it's really interesting. I mean, there's so many layers there. That one, she is, I mean, it's the sort of, that's how the ICC, addresses its gendered, indictment and prosecution. And of course, again, it's Black African woman, right? That is the first woman to be indicted. And, she's not transferred, then the focus is on the fact that she wasn't transferred. And no one's talking about the way that she was imprisoned in Ivory Coast, the way she was treated, even when she was arrested, how her body was basically profoundly disrespected. And how there's a history of that with Simone Gbagbo, right from the days of Houphouët, how she's been incarcerated for having, for being that political figure that she was. And so she erupts on the international scene, right, as a criminal without this history, right? And no one cares because, again, it's an African Black woman, who cares? And so, that makes me then think about, how trials are historicized. And the ICC, I mean, there are lots of issues around, how we can even follow what cases, right? And how difficult it is to know even what the trial schedule is like unless you really follow up close. And it's usually through other outlets that you find out. And then, of course, accessing, I guess, the video recordings of the sessions is very difficult, right? And so most people wouldn't know. And I love what Alphonse was saying about, people not knowing in the Netherlands about the ICC being, in their country, because clearly it's not for them, right? And that raises a lot of questions about, how we remember trials, which trials do we learn about, and so on and so forth. So it's like a multi-part. I just want to hear your thoughts on that. Thank you so much.
Thanks both, first of all, for great presentations and your insights. Thijs, back to your comment, which is very familiar to many of us in many settings, about what you said about the debate on history being about the past. When it comes to transitional justice, there is this always idea of going back to the past, of course, redressing past atrocities, but then how far in the past? We are familiar with all of that debate. What are your reflections on this dimension and this perception that this debate often is raised to shield from the scrutiny of colonial kind of wrongs, without necessarily how far in the past being rather a temporal, let's say, some kind of time limitation, 50 years, 40 years. So you can do how far in the past in going towards certain given atrocities that we know of atrocities from the 60s that have been dealt with. Think of genocide reparations, I mean, for 40s, even as recent. But it's legitimate then to ask how far in the past when it comes to the truth of the movement that we talked about with Greece, which is post-Holocaust. Is there any element to it in your inquiries? And what does it say about the debates we have been having here about this, the existing power structures and hegemonic influence, to speak to Alphonse's point? Thanks very much.
Thank you for your presentations, and I want to make a comment and a question about how NGO reports and actually reports of these fact-finding missions actually can create historical narratives and can also contribute to, they even can create new terms. And I would like to give an example which is outside the African context. For example, there was a fact-finding mission on Georgia, and the report that they produced was produced by European countries, I guess Finland or something like this. And there is a part on passportization. And passportization is a word that has never been used before. It is the word that they created in order to describe practices of extraterritorial application and granting of Russian citizenship abroad to the countries, the neighboring countries, to the citizens of the neighboring countries. And there was one line in this report which said that passportization practices of the Russian Federation in South Ossetia intensified a couple of years before the conflict, so a couple of years before 2008. And there is a footnote to this line which says, interview of a Georgian politician which contributed to this report. And afterwards, in these recent years, we have an emerging body of academical articles which use this word and which use this fact. They use it already as a fact that Russian passportization practices were precisely intensified 2 years before a conflict, and that is kind of abuse of right. It is a violation of principles of good neighborliness, etc., etc. I tried to research this field. I tried to access statistics, and I found out that actually we have absolutely no reliable evidence and no information at all when Russia did grant citizenship to South Ossetians. And my research results are that actually it was a very creeping process which started in 1991, and I'm quite sure that before 2008 every South Ossetian citizen had Russian citizenship because they did not have Georgian citizenship. So just coming back to what we are discussing here, it is disturbing how just one line can create the whole. It's kind of adjudicated fact, if we can call it like this. And I'm wondering, what do you think about it? And I'm also wondering how these narratives can be tested at the international courts, and maybe we will have these proceedings at the ICC, and we will see whether defense will raise these issues. Because such an important issue arose just over one interview from the involved side, in fact. This is something that probably we kind of need to look very critically.
Lynn, thank you for your really, really lovely questions and also your reflections, and also just giving us some extra information about Simone and her proceedings in Côte d'Ivoire and how they were done and how she also was dealt with. I remember very vividly as well when they were arrested, and there's a video of it, and you see both the Bagbos sitting on the beds, basically in their shirts and their underwear. I think that already said something on how they were stripped of their power, and also how they were sort of denigrated and also treated. And of course, this was the springboard for their later prosecution at the ICC. But getting to your question about knowing, I think it's a really important question. Is who is knowing, and who wants to know, and for what reason? And of course, there's distinctions between different agents who are involved in the process of knowing about atrocity. I mean, there's the local level, those who have been part of it or have seen it. And usually these are the people who already know. They perhaps contain and are bearers of knowledge. And then, of course, when we speak about international criminal justice, it's a cosmopolitan society that seeks to extract that local knowledge for perhaps cosmopolitan reasons. And so I think there's a lot of layers of translation as well, and in that process of getting to know. And a lot of things get lost, a lot of things get misunderstood, are also culturally translated, right? So how does a person from Guatemala gets to know knowledge from a local Rwandan? I think that's really complex, and of course you see in many trials that these things actually go wrong. Obviously there's also the power of knowing, and I think especially in the international justice industry, or this cosmopolitan elite, there's an arrogance that we know all about these atrocities, and I think there's really a lack of modesty. I've been to this country for 30 times now, and I also figure out the more I know, the less I know, because there's so many nuances, and I think it's really just really appropriate to also just recognize what you don't know, what you cannot know, and know the limits about yourself, what you can know, and how you deal with that knowledge, and how you present it. Then Felix, how far do we go back? I think this really depends on where you are, and I can give you some examples about the Netherlands. Obviously the Netherlands is a country with a very long colonial history of at least 400 years. And looking at the society now, in the present, there is so much struggle to still deal with questions of colonial atrocity. Right, so the first genocide that was perpetrated by the Dutch was in Banda, in Indonesia, in 1636. But in the Netherlands, this is still not a question, right? It's still not being acknowledged as a genocide or an atrocity in certain circles. But obviously those circles are political, because then with acknowledgement of such an historical injustice, perhaps come extra questions over reparations and many other things. The same for slavery. I mean, the Dutch were involved not only in the transatlantic slavery, but also in the slave trade in Asia, which was even bigger than the African slave trade. There has so far not been an official apology from the government or the cabinet, making an apology for that huge part in that joint criminal enterprise, which was slavery. And the reasons why that's being done is because there's a constituency in the Netherlands that doesn't want to deal with it because history is about identity. And narratives really describe who you are. And if you recognize that you have been a perpetrator, that says something. And people are still not willing to deal with that. So I think those are some ingredients to think about in terms of how societies do perhaps not want to recognize with their own historical wrongs. I mean, the Dutch, of course, have been very outspoken to speak about the atrocities by others, right? Easily. We do it day in, day out. But when it's an inward-looking process, it's much more difficult.
Thijs, if I may be informal, it's important. Our guest yesterday, Maurice, told me something I didn't know as a Rwandan, that they only discovered recently that there are human remains in Germany of Rwandans taken during colonization. So that's a new process, for example, they are starting. I don't know where that is going, sorry.
Yeah, no, you're right, yeah. I'm going to move a little bit faster. Marina, about NGO narratives. I think you made a really good point, and NGOs usually are the first to be on the ground. And I always like to make this comparison with babies or toddlers. The first thing they are told is their benchmark story, and they will always hold on to it. And this is the power of the NGO report. Is they're the first to report, and they can also create a narrative, and of course for very particular reasons, because they want justice, they want to name and shame people. but also explain perhaps a tropical atrocity to a Western audience and translate it into a narrative that's understandable. And I think if you talk about the case of Rwanda, for instance, in the US, but also in the UK and Western Europe, of course, the atrocity here is being described as some kind of tropical Holocaust, which of course is not the real narrative about what happened here, because of course it was a genocide, but it wasn't anything like the Holocaust, right? But it's the narrative that sort of is ingrained and it's instilled really in our thinking about what happened here. Still until this day. So my mother is reading Philip Korovich's book now, which tells that story, and it still lingers. Because it's the first narrative, and that's the power of the first narrative. For a very practical reason, I can't deal with all the tribunals in one book, so that would just be too much. I also think the IC2I is a bit of an outsider in international criminal justice, because it was quite successful in what it's did and what it could do. It was also massively supported through finances and Western governments. Also, there's a lot of literature on it, and I don't think there's any reasonable or good amount of sources on trials on Africa, really. I mean, there's hardly any book on it. So that's a bit of the reason. Sarah, on your question, just to answer it very briefly, I think if tribunals were to uncover and write history, they should swift towards an inquisitorial system. I mean, if a tribunal wrote some history, I think it was the Extraordinary African Chambers, which was really an inquisitorial system of 30 years, really starting in the 1990s, with victims' testimony, and also the victims actually being so much an integral part of the proceedings. Right? If you went to Senegal, there were 90 witnesses. All victims telling their stories, and the judges actually wrote that down in their judgment. And I think there's much more history to be found in that judgment than, for instance, reading the Bakasora judgment, which is totally different. So I think there could be a turn towards a more inquisitorial system, and perhaps also just involve more social scientists in investigations. I worked as a historian at the ICC. But Luis Moreno Ocampo didn't like social scientists as much as he didn't like police, so he just fired everybody and just hired lawyers. And perhaps that's also the reason why they were not very good in getting the history right. Yeah.
I would want to ask you, which is, and I think you talk about it, the procedure itself and how it affects getting the truth. For example, if you take the case of Z case, who was acquitted on the technical ground that the burden of proof was put on him, not on the prosecution, and for that reason gets acquitted. You can talk of the guilty plea process, which in the bargaining you allow me to say some and not others, and how that so is. And we asking too much courts, which essentially are not supposed to be delivering on.
Okay, we have another round, so Jill's hand is up. And then who else? Okay, so
what I'm interested in is, outside of those binary perspectives, what did you find in your research in the grey zones? So I'm thinking of people who are sort of broadly supportive of the ICC and ICJ as an enterprise, but are critical about specific aspects of the court. People who were big believers in the whole enterprise at the outset and then maybe lost faith over time and now have become very angry about it. I think there are even some commentators who might have gone in the opposite direction, kind of skeptical of this thing at the beginning, but are quite pleased by the very pragmatic approach that the court is taking. So I just wonder where in your analysis that sort of middle ground, that more ambiguous ground of opinion fits. Because I think there are lots of people in that category. I mean, I don't put myself in that category, but I think there are lots of people we know who would be in that category. And analytically, I just wonder where that fits into your analysis. Thanks.
Great, my questions for all at once. I was really moved by your descriptions of arriving in The Hague and some of your accounts. really go quite some way to really reflect on this idea of international criminal justice and international criminal institutions as heavily involved in reinscribing and redefining race, right? And thinking about this racial ordering that we can reflect on. The question I wanted to ask you is that doesn't seem to have prompted for you personally a turn away from these forms of justice, right? There still is in your work quite some faith in these formal institutions of international criminal law, like the ICC. And so I just wanted to ask you, or invite you to reflect on that a little bit.
Yes. Thank you for the questions. Because my first internship, well, it wasn't really an internship. I was at the ICT, I was referred to as a research student because I was working on my dissertation. And I wasn't quite much involved in their work. I was observing, interacting with whoever I wanted to interact to, and getting to whatever events that could be organized and attending hearings. But at the ICC, we had really an egalitarian kind of working relationship. But all that depended on the office and people who occupied those offices. And I think the reason for that kind of relationship was mainly because we really didn't know what to do. You would wake up one morning, suggest something, and we would sit the entire day discussing about it.
Thank you both so much for your presentations. My question is to Alphonse. Earlier in the week, we heard from Florida and about her experience as an intern at the ICTR, and she discussed the lack of diversity, how she was predominantly used for her language skills, and just not being given tasks that were to her skill set. I was wondering what your experience was like as an intern, and if you experienced anything similar.
I wanted to thank Alphonse for that story. It was really such a masterful story. It got so much done. It really kind of brought to the fore the way in which we walk through the world with different histories and experiences, and we're all full of implicit bias that we don't know about, and how it kind of calls on us to figure out how to interrogate ourselves about the assumptions that we have that we don't even know that we have. I thought it was really powerful, and it really was a great way to talk about the problem of masked power. And I don't really have a question, I just wanted to thank you for that, and also ask, have you published that anywhere? Because I would so love to use it in my teaching.
Yeah, thanks, Alphonse. I apologise, Thijs. I missed your presentation. Alphonse, one of the things I really love about your book, as well as your presentation, was this incredible juxtaposition of the different perspectives on the ICC. The kind of critics and supporters dialogue that runs all the way through the book, I think, is really innovative, but I think it captures a lot of the schizophrenia around the court and international criminal justice at the moment. What I'm interested in is, outside of those binary perspectives, the very pragmatic approach that the court has taken. So I just wonder, where in your analysis that sort of middle ground, that more ambiguous ground of opinion fits?
So to me, that was really a very good experience. Middle ground, I can say that people who have interacted with ICC or have worked with ICC are in two categories. They are professionals, people who really are interested in developing their career. They are those who have faith and want to change things. The category of those who want to change things are all disappointed. Those who are simply interested to be career professionals are still there. And that is, as one person whom I can't remember, who argues that is the bad thing about bureaucrats. When things go wrong, they will tell you, we were just following the law. But generally, I would say, and in response to Sarah's question, I still have some faith in these institutions if they are willing to be humble.
The poser that Alphonse asked is about being humble. It's very important, but the issue is going to be can't really be humble. And it also it taps into this hierarchy of power, the whole international project, funding, even not even that, even the funding of the international system. But I was thinking about something before the humility thing came, was what I wanted to ask Alphonse was this idea of resilience. We have a lot of people around us here, students that want to work for ICC, international organizations, and how do we build resilience? And in building resilience, that's how we can hold them accountable. What does that mean? When we try to, based on my experience working for different regional organizations and also for ICC, I find that it's a little bit demoralizing for you emotionally when you work in a space where you are not acknowledged, your contributions are not acknowledged, you are just by the side, you have some order that are given a space to. So how do you overcome it? The first distinct that you have is either to be rebellious or to shut down. Most people shut down and say, I just want to get my daily bread and just get away. But I think beyond that, we need to rise above, and I think Kamari spoke about it yesterday or when we were at Rwanda University, where we need to get the knowledge, not only get the knowledge, interrogate the existing knowledge that's been produced and carefully curated for us. And that's what we have been doing for the last 1 week. And beyond that, there's something that I remember when I was in conflict studies world, when they cite the most dangerous countries to live in the world, they always talk about Africa, but that's not correct. Syria for the last 5-10 years has been bombarded, that even the international commission has given up on them. Now we have Ukraine, but if you look at the data they were citing, the data were from 1990s during the Rwandan genocide, during the Sierra Leone war conflict, during the Liberia conflict. And again, to hold them humble, which is our task as third world scholars or as African scholars, is to get our knowledge and reconstruct the knowledge that we produced before we came on the scene. So that is one aspect of it. But to do that, you have to build resilience. And resilience means know your purpose in the space of international world. Why am I here? Is it just to make money, or is it just to contribute to knowledge production? If it's contribute to knowledge production, which I think all of us should embrace, then we need to interrogate the existing data and bring out something useful to hold them on. But in terms of whether it's going to work, well, we'll keep doing the work.
What is humility? So in the West or the global North, we think of humility in a way that might not be always a cultural value to which one aspires. In other places in the world, including in Rwanda, it is the foremost value for many. And so Sarah has her hand up, but maybe you could say something else about the workings of humility as a domain of power, in fact, as a quite vigorous domain through which we engage and rethink the future and rethink justice.
Thanks, Kamari. I didn't want to jump before Alphonse, but I just quickly looked up the etymology of humility, and it comes from the Latin, and it's linked to the concept of being grounded and of the earth. And I think there's maybe something there, but then connected to what Kamari was saying, I'm wondering maybe there's a kind of exhaustion of English at this point, and what other ways of thinking about this might we be able to draw from other languages?
I love the direction this is going in, and so I just wanted to, one of the things that came out for me in your narrative, Alphonse, very, very powerfully, is the notion of a particular kind of taken for granted cosmopolitanism by the ICC and by other kinds of institutions, and one kind of cosmopolitanism that doesn't necessarily allow, for example, for what people are bringing up around this table now, the idea of what humility might mean, what different concepts might mean within that notion of cosmopolitanism. And you've told us, the various, like the whole travel narrative and the way that, it's get out of the airport, go to track 4, take this train, then, do this, and then you're there. But also, what that implies in terms of the knowledge that is assumed, and the other knowledge that is eluded. that is considered to be not as important when one enters these spaces?
For me, I see humility from the fact that of acknowledging that you can't know everything. You know, these institutions, we talk of ICC, but ICC is nothing as an institution. The institution doesn't say anything. It is about the individuals that occupy the offices, who speak and act on behalf of the institution. And as human beings, we have limitations. And if at least we could acknowledge that and go into these places of where we have the mandate, knowing that there are certain limitations that we have, and acknowledge that there is what other people from different backgrounds than that of ours can contribute to the success of what we are doing. G asked about whether I forgot to answer that, whether he wants to write a book or I've written a book about it. I have not thought about it. Now my preoccupation, I was sharing it with Sarah, is to reflect on governance. Because governance is another area which we feel we have stopped our thinking. Yet, as human beings, we pride ourselves in creativity. And this important thing in our lives, which is governance, we have said liberal democracy is the only form of governance, full stop, which I struggle to understand. So, at the moment, when I finish reading Kamal's book, which is 1,200 pages, which I have promised myself to review, I will turn to that. Thank you very much.
Oh, that one.
Complex question, and I think it also ties in a little bit with what Phil was asking about, is what position we take as scholars or scientists even towards a field that is so incredibly political. I think the first question is really also, as a scholar, do you want to be part of it? Do you want to have part in the conversation on how to shape it in the future? Because it's a research object, right? Do we want to change it? And then what does it say about ourselves as well as researchers? Just to clarify, I've been asked to be an expert witness many times in trials, and I always refuse because I'm studying these cases. I cannot be part of it. Also, I don't want influences, and perhaps I also just want to be modest. And I think that's the word I'm borrowing from Alfonso, perhaps not being in a sense of humility, but more just modest in what you can actually contribute to the field and understanding the field. And I really like what Alfonso said, is that the ICC is nothing. I agree. And because it exists only by the power of words of its agents and its protagonists and the promises that it makes. And really these are lofty promises, right? What can an international criminal court really contribute? If we look at Hannah Arendt and just read her words that a criminal trial is nothing else than just looking at whether a defendant is guilty or not and then agree, perhaps, on sentence. But there we have the international justice system that believes that it can bring peace to war zones, can reconcile fractured societies, can heal entire communities, can repair former harms done. I think the international community that also supports the international justice industry lacks a lot of modesty in terms of what it can realistically achieve and also what its position is in the world. So again, the ICC in the larger spectrum of transitional justice and world politics, of course, it's nothing. It's just a very tiny element of world politics. I think I'll just